You have a criminal mischief. Then you had another theft case from 2018. But then you had another aggravated assault with a deadly weapon. And now you're here on another aggravated assault with a deadly weapon. So that I don't think you would be a good candidate.
3 cases, 1 courtroom, 1 judge who has clearly run out of patience for excuses. Tonight's first case, Alicia Jimenez, a woman standing before the court asking for deferred adjudication. A legal lifeline that could keep a felony conviction off her permanent record. Her daughter is here to vouch for her. Her attorney has filed a sentencing memo. She's even written a personal letter to the judge about finding God behind bars. But here's the twist. This is not her first aggravated assault with a deadly weapon charge. It's not even her second serious offense. Before the judge says a single word of ruling, she's already flipping through a criminal history that includes theft, resisting arrest, a prior probation that was terminated unsatisfactorily, an earlier 4-year prison sentence for the exact same type of violent crime she's charged with today. Will faith, family testimony, and a letter of apology be enough to earn a second chance? Or has Jimenez already used up every chance the system was going to give her? Then, in case 2, 26-year-old Ruben Solano faces the court on a drug possession charge. But what really gets exposed isn't the drugs, it's his personal life. A child he hasn't seen in months, no job, no plumbing license, living off his grandmother. Watch how differently this judge handles accountability when it's not a violent crime. Let's get into both.
015787 State versus Alicia Jimenez. Can I have parties announced?
For the state of Texas.
Sharon Thorne for the defendant, Your Honor.
Alicia Jimenez.
All right, thank you. All right, Ms. Jimenez, you entered a plea to count 1. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. They're taking in consideration 2025 CR 015767-02. There's to be no contact with the complainants, and there's an affirmative finding of deadly weapon. Did both parties have a chance to review the? Yes, that's yes. Yeah. No, that's okay, Rick.
Yeah.
All right. Yes. All right. Have both parties had a chance to review the PSI report?
Yes, Your Honor. State has no objection.
No objection. I've reviewed it with my client. No.
All right. The state is silent. Any witnesses?
Yes, Your Honor. Before I get started, I would like to call her daughter, Destiny Stewart.
All right. Destiny Stewart.
Jimenez.
All right. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. State your name for the record.
My name is Destiny Stewart.
All right. Defense, you may proceed.
Thank you. Destiny, how are you related to Alicia Jimenez?
That's my mom.
Okay. And how old are you?
28.
28. Do you have children?
Yes.
How many children?
I have 5.
5 children. And do you live here in San Antonio?
I do.
Okay. Is your mother, and she's not in jail, was she a part of your life and your children's life?
Yes.
And how attached are your children to your mother?
Very attached.
Okay. Does she help you raise them?
Yes.
Are you asking this court to grant her deferred adjudication so that she can continue to be in the community and help you and your children?
Yes.
Okay. Do you believe that that would be in the best interest of your children and of your mother?
Yes, it will.
Do you understand that if she were to be granted deferred adjudication, there she would have to do probably a lot of things with probation, go to classes, report, and stay out of trouble? Would you be willing to support her in that way?
Yes.
And would you make sure that either she had a ride or was going to all the classes and things that she needed to do?
Yes.
And do you believe that your mother would be successful if she were to be granted deferred adjudication?
I do. Yes.
Okay. You are aware that your mother has some criminal history,
Yes.
but you're not making excuses for your mom.
No, absolutely not.
You're just asking this court to take a chance on her and give her a chance.
Yes.
Okay. That's all I have, Your Honor, of this witness.
All right. Any questions? All right. I have a few questions.
Yes, ma'am.
Any objections?
No.
All right.
Can ask you some questions.
So does your mother have any mental health issues?
Yes.
And can you tell me what that is?
Don't know too much of her health issues, but I know she does have some. I know when I was younger, she would see a doctor. She wouldn't really tell me much of why she saw a doctor, but when I was little, she was pretty much stable. when I became an adult is kind of when things got more rough.
Okay.
That testimony from Destiny is exactly the kind of moment that makes these hearings so hard to watch. A daughter, only 28, raising 5 kids of her own, standing up in court to vouch for her mother. And even she admits she doesn't fully know the extent of her mother's mental health struggles, only that things got noticeably worse once Destiny became an adult herself. That's a subtle but important detail. It suggests a pattern that's followed this family for years, not something that appeared overnight. The defense is building an emotional case here. Grandchildren who are attached to her, a daughter willing to provide rides to classes and probation check-ins, a family desperate to keep her out of prison. But emotional testimony and criminal history are about to collide head-on in this hearing. Because family loyalty doesn't erase a record, and the judge is going to want a lot more than love from grandchildren before she considers deferred adjudication for a repeat violent offense.
All right. Thank you so much. Next witness.
Very nice. Your Honor, before I call my client, I also wanted to, I filed a sentencing memo, and I think you should have a copy, but the letters that you have attached to your sentencing memo came out really blurry, so I have a hard copy.
Thank
Right.
you.
This is my sentencing memo
Any
along with.
objections to the court reviewing this? All right. Any other witnesses?
Yes, Your Honor, I would like to call my client at this time.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. And is there any objection to the court reviewing the PSI report?
No, Your Honor.
Okay. So just give me one moment with that. All right. So when questioning your client, if you can clear up for me, because in the PSI report, it's stating that she is minimizing guilt. And in the PSI report, she seems to argue that this is self-defense and that she has no idea what's going on. So if she wants a jury trial, then, we're here for that.
Ma'am,
All right.
proceed.
Yes.
State your name, please.
Alicia Monique Jimenez?
And you understand why we're here today?
Yes.
And you pled no contest to this offense of aggravated assault, correct?
Yes.
Okay. Now you understand what the judge was asking, and those are some things on the PSI that you and I discussed. And you tell the judge now today, do you accept responsibility for what happened?
Yes, I do, Your Honor.
And you understand the charges against you?
Yes, I do.
Are you asking for a jury trial?
No, I'm not.
Are you making excuses for what happened?
No, I'm not.
And you understand that there was a complaining witness, a victim in this case,
Yes, I do.
and that's why we're here.
Yes.
And you're asking this court to grant you deferred adjudication, and you're not making excuses for what happened.
No, I'm not.
With that, Your Honor, I'd like to continue with questions.
All right. So she's not going to be alleging self-defense.
No, Your Honor.
Okay. All right. You may proceed.
Thank you.
Thank you.
Okay. Now, you and I've gone over this PSI, and we've gone over the facts of the case. We've gone over your criminal history, correct?
Yes.
And you acknowledge and own your history. You know what you've done and the things that, in fact, you've been to prison for, right?
Yes, I have.
Okay. Knowing that, you were still asking this court to grant you deferred adjudication and give you a second chance.
Yes, ma'am.
Your mother's here, correct?
Yes.
And your daughter's here. Your mother, she went to TDC, correct?
Correct.
And in fact, when you were 14 is when your mother went to TDC and you ended up in foster care.
Correct.
Would you agree that that kind of started the spiral of problems that you have?
Yes, that's true and correct.
Okay. But again, we're not here making excuses, right? Okay. Now, since you've been in custody here in Bear County, is it true that you've been involved in Bible classes?
Yes.
And would you agree that you've kind of awakened your spiritual side?
Very much so.
In fact, that letter from one of your fellow inmates, they recognize that you are doing much better and you're kind of a leader at the jail.
Yes.
And you are trying to be better and trying to have a better life and better life for your children or your grandchildren
And my mother.
and your mother.
Yes.
Okay. You wrote a letter to the judge,
I sure did.
and would you like to read that letter?
Yes.
And
Is that okay with you?
With your permission,
Uh,
Your Honor.
Well, it's fine with me. However, the state will need to review it.
Okay. Okay.
And then once they review it, if they're fine with that,
Okay.
then I
Thank you.
will listen, of course.
And while they're reading it, could I ask for some more questions?
Yes.
Okay. Now,
We'll just.
so, and I know you told probation and you tell the judge that you have some serious health problems. High blood pressure,
High blood pressure and
severe asthma, depression, you've been diagnosed with depression, anxiety,
anxiety.
bipolar 1 and 2,
Yes.
PTSD,
Yes.
and ADHD.
Yes.
Do you take medicines for those diagnoses?
Yes, I do. I was enrolled in Alamo Premier. That's my psychiatrist, and I also take medications here in the Bericon.
Okay. So prior to your incarceration, you were seen a counselor and therapist,
Yes.
and if you were to be continued or granted deferred adjudication, you would continue with that, and they would monitor your medications,
Yes.
and they would make sure that you're seeing. Is it a psychiatrist you see?
Psychiatrist and a counselor.
And
at
a
the same
counselor.
place.
Okay.
I was gonna leave that out.
Oh, no,
I
Just
wrote
have
letter
a
and I was gonna
moment
leave
with
it
my
out.
client.
sure.
Yeah, I was gonna leave it out. I know it was, yeah. Yes, I was gonna leave that out.
Okay.
I'm nervous. I'm sorry.
It's okay.
I apologize.
Okay.
It's been a long 8 months.
Yeah, no
Okay.
problem.
Can I read it to you?
Yeah.
Sure.
I can basically just tell you, that I wanted to apologize to my victims, apologize to you, Judge Boyd, to my attorney and to the district attorney, and especially my family for putting them through the pain and the cause. With that being said, that it doesn't define, the reports do not define who I am. I'm a very loving mother. I'm a very loving grandmother. And I care for my mother who is here, who is ill.
Mhm.
I was known to have sufficient, I have been known to have,
No,
be
no.
sufficient and dependable. I'm a caregiver, like I said, to my mom and a provider to my grandbabies. I've also surrendered myself to the Lord Jesus Christ, who is capable of forgiving, healing, and changing me for the better. I come before you to ask if you would consider giving me another opportunity to a fresh start, to a new life, and to a better career to educate myself. I want to be a service to my fellow church. I also want to help change lives. I was thinking about trying to get into prison ministries to help the broken and to minister them. And with that being said, I just wanted to be able to share my accomplishments with my family. And I want you to know that I would make better choices. And thank you for your time.
All right. Thank you so much.
Jimenez's letter is genuinely moving on the surface. Faith, redemption, prison ministries, a desire to serve her church and provide for her grandchildren. It hits every note a sentencing memo wants it to hit. But letters like this are exactly why judges lean so heavily on documented history instead of a single moment of testimony. Anyone can write about a fresh start. A stack of prior probations that ended in violation can't be talked around the same way. And here's the detail worth flagging before we move forward. Her attorney already told us this is repeat aggravated assault with a deadly weapon charge, following a prior 4-year prison sentence for the same offense. A judge weighing a heartfelt letter against that kind of documented pattern is facing exactly the dilemma the justice system was built to test. How do you balance genuine remorse against genuine risk? We're about to find out which one wins.
All right. Any other questions?
No, Your Honor, I believe she really said it all. We were just asking, on behalf of her and her family, for you to consider deferred adjudication. I know it's kind of thinking outside the box with her record, but I believe that she's come to hopefully a change in her life. And I think we would have a good choice in granting her deferred. And as I stated in my sentencing memo, if you were to give her deferred, you would still have a big, huge hammer over her head. And if she messes up, I explained this to her, she's looking at 20 years and you would have that over her. But I think And I hope that you would consider deferred adjudication and that place her on 10 years deferred adjudication with all the bells and whistles that are needed. And I do believe that she'll be successful.
All right. So, Ms. Jimenez, this is what I can tell you. It would be nice if I had something in front of me that could tell me how people will behave or whether they will be successful on probation or not, whether or not if I place them on probation, they're going to commit new offenses, but I don't have that, right? So I just have to look at evidence before me and consider things as a whole, right? And so I don't think you would be a good candidate, and this is why. I don't think you'll be a good candidate, but I can tell you right now, I'm not going to sentence you to the 12 years. This is why I don't think you'll be a good candidate. You've been on probation before for assault, family violence. And I realized that was a long time ago in 2001, but it was terminated unset.
Yes, ma'am.
All right. And your attorney knows what terminated unset means. Now, you have a lot of cases that have been dismissed. I'm not even considering those because they were dismissed. I don't know what they were dismissed for. You have a criminal mischief from 2009. You did time. They gave you a judgment satisfied. Then you had another theft case from 2018, judgment satisfied. A resisting transportation, that's the same time frame as the theft case, judgment satisfied. Then you had the abandoning of a child case. And with that, there was a motion to revoke file, and then they terminated your probation unsatisfactorily. Then the other cases where they say, oh, we dismissed it for a missing witness, I'm not considering that all because I don't have any facts for that. But then you had another aggravated assault with a deadly weapon. And for that one, you received 4 years in the prison.
Yes, ma'am, I did.
And that's from 2020. And now you're here on another aggravated assault with a deadly weapon. So that's why I don't think you're appropriate for deferred adjudication. So the court is not going to grant your application for deferred adjudication. What the court will do, the court is going to find you guilty. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2025 CR 015767-02. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Ernesto Coronado or Luis Luvano. There's to be no unsupervised contact with minors, and the court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it, and did you sign it?
Let's break down exactly why this ruling landed the way it did, because the judge basically gave us her reasoning in real time, a rare thing to get so clearly on the record. She wasn't swayed by the letter, the faith journey, or the family testimony, and she said so directly. She doesn't have a crystal ball to predict future behavior, only the documented pattern in front of her. And that pattern was damning. A prior probation terminated unsatisfactorily, multiple judgments across theft and resisting arrest charges, a prior aggravated assault with a deadly weapon that already resulted in 4 years of prison time, and now a second identical charge. In Texas, terminated unsatisfactorily is a specific serious marker. It means a previous chance at supervision instead of prison was given and it failed. That's exactly the kind of documented risk factor that overrides an otherwise compelling personal narrative. Notice also that the judge chose 7 years. Well under the 12-year cap in the plea agreement, a middle ground that denies the leniency of deferred adjudication while still not maximizing the punishment. That's not mercy exactly, but it's not the harshest outcome available either. Case 1 is now closed. Let's move to a very different kind of hearing.
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. And what I will do, if I didn't say it, I'll put in there the therapeutic community for mental health. And I'll also let them know therapeutic community just based upon the stipulations for any type of drug or alcohol issues.
Thank you, Judge.
Court is calling 2024 CR 6514, State of Texas versus Ruben Solano. Can I have parties announced for the record for the state,
Andrew Sidney.
defense?
Deborah Burke, Your Honor.
And are you Mr. Solano?
Yes, Your Honor.
Did you review the discovery counsel with your client and have you received it all from the state?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Solano, did you review the document entitled Application for Community Supervision with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waive it.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Solano, did you review the document entitled Court Admonishments with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Solano, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, your community service is to be for a term of 3 years. There's to be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
And then that's Your Honor.
No objection.
State you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would like to.
Anything you wish to say on behalf of your client?
I hope you follow our plea agreement, Your Honor.
All right. When's the last time you had employment?
I was almost self-employed, so I work for myself.
Doing what?
I do, I'm a jack of all tradesmen. I do plumbing,
Well, do you have a
Mechanical.
license to do plumbing?
no, ma'am, I sure don't.
All right, so you
Yeah.
need to work on that
Yes, ma'am. So,
because then that means that you're depending on people just calling you instead of a plumber
yeah,
calling you.
okay.
How far did you go in school?
9th grade.
Why?
I had a kid at 14 years old, so I had to drop out of school and start working.
And when's the last time you saw your child?
My child been like 3 months, 4 months,
And how old is your child?
7 months. So 7-month-old baby right now.
Well, wait a
Oh,
minute.
What
oh,
about?
oh, my
when you were
20-year-old.
14, you had a
Oh, yes,
child.
yes, yes.
It's like
No, I'm talking about now. I'm talking about.
something's wrong with the
No,
time.
no, I'm sorry. I'm sorry. No, I haven't seen my child like forever.
All right, so now you have a 7-month-old.
Yes, I'm a 7-month-old baby. Yes,
And who does the 7-month-old live with?
with her, with his mother.
All right. And who do you live with?
I live with my grandma.
All right. Everybody always wants to put a bunch of problems on their grandmothers.
No,
You're an adult, get a job.
I know.
You know, live by yourself. Your grandmother just
Well,
wants to be a grandmother.
Yes,
This exchange with Solano is a completely different tone from the Jimenez case, and it's almost uncomfortable in a different way. No violence, no deadly weapon, just a state jail felony for a tiny amount of a controlled substance. But the judge isn't just processing paperwork here, she's doing something close to an intervention. No plumbing license, despite calling himself a tradesman. 9th grade education because he has had a child at 14. Hasn't seen that teenager in years and now has a second child, 7 months old, that he's barely seeing either. Living with his grandmother well into adulthood. The judge's line, "Your grandmother just wants to be a grandmother," is blunt, almost parental, but it's pointing at something real. A cycle of dependency and disrupted family structure repeating itself generation after generation. Is tough love like this actually more effective at breaking that cycle than sympathy would be? Or does it risk feeling like judgment dressed up as advice? Either way, watch what sentence actually follows. It's far more lenient than case 1, and it comes with a very different set of conditions.
Okay.
Your Honor.
All right. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. $2,000 fine, that'll be probated. You're going to get employment, not this, I'm just a handyman. Not that there's anything wrong with that. Handyman is supposed to be
Like,
a side job. You have your regular job and that's for extra income. So there's to be proof of employment within 30 days of release.
Gonna be in jail for a minute.
All right, why is he in jail for a minute?
It's an assault case, not indicted.
All right. There's to be no employment as a home healthcare provider or with minors. We'll do the TAP evaluation in custody.
Okay.
Follow recs. There's to be no unsupervised contact with minors. There's to be 120 sober days. I'm sorry, 120 sober meetings in 120 days upon release.
Excuse, will you repeat that just so I can understand?
120 sober meetings and 120 days upon release from custody. There's to be 150 community service hours. 50 of those hours will be waived upon completion of parenting classes. The remaining 100 hours will be waived if you obtain a trade school certificate or obtain your GED. Field visits 1 time per month for 6 months upon release from custody.
That means a home visit
Yes,
once a month for 6 months.
yes. Probation, is there anything else he needs? Oh, thank you. Regular reporting by Zoom or in person. And we're going to do the UA hotline until further notice. All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. To be successful in this court on probation, communication is key. If you feel as though you're going to use, don't sit at your house and just think, oh, I'm going to use, I'm just going to see what happens. Pick up the phone, call probation, say, I'm struggling right now. They'll get you the help you need. If you feel as though they're not addressing it, you can always come back to court and I'll address it. Do you understand?
Yes, Your Honor.
Good luck to you.
Thank you.
Closing moment between the judge and Solano is honestly one of the more human beats you'll see in a courtroom setting. If you're struggling, call probation. Don't wait until it becomes a violation. That's a judge trying to build an actual support system into a sentence, not just hand down punishment and move on. And look at how differently his outcome landed compared to Jimenez. 2 years, fully probated, with a genuine path to reduce his community service hours through parenting classes or education. No prison time. That's the system explicitly choosing rehabilitation over incarceration for a low-level non-violent offense, a sharp contrast to the 7-year sentence just one case earlier, where a repeat violent pattern made deferred adjudication a non-starter. Same courtroom, same judge, same night, but two completely different calculations about risk, history, and what actually protects the public. Now let's close out with the final read on how this whole session should stick with you. So here's what tonight's docket really taught us. Alicia Jimenez asked for deferred adjudication on a repeat aggravated assault with a deadly weapon charge, backed by family testimony and a heartfelt letter of faith and redemption, but a documented history of a prior unsatisfactory probation and an identical prior conviction meant the court couldn't justify the risk. Result, guilty finding, 7 years in prison, no chance to appeal. Ruben Solano, facing a much lower-level state jail felony for drug possession, walked away with a fully probated sentence and a real structured path toward stability. Parenting classes, a GED or trade certificate, sober meetings, and a judge who explicitly told him to call for help before things spiral. Put side by side, these two cases are a masterclass in how the same courtroom, same night, same judge, weighs documented risk against genuine rehabilitation potential completely differently depending on the pattern in front of her. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.